Hello, everybody. We're going to get started. Thank you very much for registering and joining our webinar today, The Public Charge in the Time of Coronavirus, What the Community Should Know. My name is Sara Cartagena, and I'm the Immigration Analyst at the Latino Policy Forum. Before we get started, I just want to mention that I would appreciate if everybody please stays on mute during the presentation to make sure that everybody can hear. Please enter any questions that you have during the presentation in the chat box. We will have two Q&A sessions during this presentation, one midway through and one at the end, just to make sure that everybody gets a chance to ask their questions. The public charge can be confusing and complex, so I want to make sure that everybody understands it. I also wanted to note that there will be a presentation in Spanish at 1 p.m. as well. So that being said, let's get started. To start, I just wanted to share a little bit about the Latino Policy Forum. We are a statewide policy organization that focuses on advocating for early education, advocating for just housing, advocating for just immigration policies and laws, and strengthening leadership, community leadership. Our agenda for today, we will review the public charge. We'll go through what is a public charge, who does it affect, and who does it not affect, how is the implementation of the final public charge rule, and then we'll have that first Q&A. The second portion will go over COVID-19 and public benefits and assistance related to COVID-19 and what's available to non-citizens and the effect that they have on public charge. We'll end it with common questions and important messages and resources, and then we'll have that second Q&A. I did want to mention that this presentation is not legal advice. It is only an informational presentation on the public charge. So to start off, what is public charge? The public charge is a test that immigration officials give to individuals who are seeking to enter the United States or are seeking to adjust their status to legal permanent resident or green card holder. This public charge test consists of the immigration official considering a number of factors that is called the totality of circumstances when they make the decision of whether that person is likely to become a public charge in the future. It's important to note that if an official determines that an immigrant is more likely than not to become a public charge in the future, the application for a green card or entry to the US may be denied. And we'll talk more about this totality of circumstances and dive in a little more later on in the presentation. Now, the public charge final rule can refer to two similar but different rules. The first one is the public charge rule for applicants, so visa applicants and green card applicants outside of the United States, which is administered by the Department of State. This rule is temporarily blocked, so it is suspended from going into effect right now. The second rule is the rule for applicants from within the United States, which is administered by the Department of Homeland Security. And this rule is in effect. It went into effect in February of this year, and despite ups and downs in the courts, it is currently in effect right now nationwide. Sorry. And this presentation will focus mostly on that second rule for the applicants that are applying from within the United States. Now, who is subject to the public charge test? As mentioned, immigrants who are applying to enter the United States, extending or changing the status of their non-immigrant visa, applicants that are seeking to become a lawful permanent resident or a green card holder, and then legal permanent residents who re-enter the United States after spending more than 180 days consecutively outside of the United States. This is the only time that a legal permanent resident will be subject to the public charge test, when they leave the United States for more than 6 months and re-enter. So if you are a legal permanent resident who thinks will spend more than 6 months abroad, you should consult an immigration lawyer. Now, not all immigrant categories are subject to the final public charge rule. There are many categories that are exempt. This is a list of a few important ones. So refugees and asylees are exempt from the final public charge rule. Survivors of trafficking, violence, and other serious crimes, such as U visa, T visa, and VAWA self-petitioners. Persons that are protected under the Cuban Status Adjustment Act. Special immigrant visas, holders for Afghanis and Iraqis working as translators, persons protected under the Nicaraguan Adjustment and Central American Relief Act, special immigrant juvenile status holders, legal permanent residents who are renewing their green card or applying for citizenship, naturalized citizens, and many other categories of humanitarian visas. So this is very important. These are just a list of the few immigrants who are exempt from the final public charge rule. And who does the public charge mostly affect? The public charge mostly affects those who are seeking legal permanent residency based on a family relationship. So this includes spouses, children, and unmarried adult sons and daughters of a US citizen or a legal permanent resident, as well as parents, siblings, and married sons and daughters of a US citizen. So these are the people that will be mostly affected by the public charge rule. Now, this is a question that we get a lot. So how does it affect DACA recipients? Well, the public charge test is not applicable when a person is applying for DACA, nor is it applicable when a DACA recipient is renewing their DACA. But that does not mean that DACA recipients are exempt from the public charge rule. For example, if a DACA recipient obtains a pathway to legal residency through a family-based relationship, such as marrying a US citizen, then they would be subject to the public charge.
Sarah, sorry to interrupt. I have a coworker who's in like the waiting area to be let in.
Okay. Yeah. No, thank you for letting me know. This is like a one girl operation, so thank you. Okay, awesome. And so I quickly wanted to go through the public charge litigation, just because, as I mentioned, there has been a lot of, activity in terms of like public charge in the courts. So the public charge final rule was meant to go into effect on October 15th, 2019, but a federal court put a stop to the rule a few days before. In January of this year, January 27th, the Supreme Court allowed the public charge to go into effect nationwide, with the exception of Illinois, which had its own block at the state level. On February 21st, the Supreme Court lifted that Illinois court block, allowing the public charge rule to go into effect in Illinois as well. That leads to February 24th of this year, just a couple weeks before the COVID-19 pandemic, where the final public charge rule went into effect nationwide, including the state of Illinois. Now, in July of this year, a federal court in New York blocked the final public charge rule nationwide due to the national emergency of COVID-19. But on September 11th, the Second Circuit Court lifted that block, allowing the public charge to continue nationwide. So that means that currently the public charge rule is in effect nationwide, including Illinois. So as I mentioned, this final public charge rule that went into effect in February is still in effect in Illinois. It's important to note that green card applications that were sent before February 24th are not determined under the final public charge rule, and the use of non-cash benefits before February 24th of this year will not be considered. So the use of those newly listed public benefits under the final public charge rule will not be considered under February 24th, 2020, but if you continued using those benefits after that date, they will be considered. Now, our next section is how is the implementation of the final public charge rule? So the first important thing to note is that there's been changes to the definition of a public charge. So the previous definition that was followed, that was under the field guidance of 1999, was a public charge was an immigrant who was likely to become primarily dependent on the government for subsistence. Now, the new definition under the final public charge rule is a person who receives one or more public benefits for more than 12 months in the aggregate within any 36-month period, such that, for instance, receipt of two benefits in 1 month counts as 2 months. Now, as you can see, this new definition is very confusing, especially that part that says that, for instance, receipt of two benefits in 1 month counts as 2 months. So I try to break it down with an example here. So Consuelo receives SNAP, Medicaid, and Section 8 housing voucher for only 1 month. Under this final public charge rule, this is equivalent to Consuelo using 3 months of the listed public benefits, because each public benefit that she uses, so SNAP, Medicaid, and Section 8, each count as 1 month of use within that 1 month period. So she is considered to have used 3 months of the listed public benefits. Now, what are these public benefits that are listed under the final public charge rule? The ones on your left that are in black are the ones that were included in the public charge definition before the final public charge rule, so under the 1999 field guidance, and that continue to be included. So those are the government cash assistance for income maintenance. This could be the temporary assistance for needy families, known as TANF, supplemental security income, known as SSI, or cash assistance from state, local, or tribal governments, for example, general assistance. And also long-term medical care in an institution paid for by the government, so such as a nursing home that is paid through, for example, Medicaid. Now, on your right, the ones in orange are the newly listed public benefits under the final public charge rule. So those are the Supplemental Nutrition Assistance Program, known as SNAP, or food stamps, federal public housing, such as the Section 8 Housing Choice Voucher, the Section 8 Project-Based Rental Assistance, which includes the Moderate Rehabilitation Program and public housing, and also Medicaid that is funded by the federal government, for example, the ACA for adults. But Medicaid has many exceptions, which are not included under the public benefit, under the public charge. And that is emergency Medicaid is not included, Medicaid for persons under 21 years of age, Medicaid for pregnant women, including those 60 days postpartum. Services under the Individuals with Disabilities Education Act is also not included. So there are many exceptions under Medicaid. And I do want to note that the programs that you see on this page are the only public benefits that are considered negative under the public charge rule. Now, what benefits are not included then? As I mentioned, the Medicaid for people under 21 and pregnant women. This includes all kids, CHIP, mom and babies. The emergency Medicaid is not included. COVID-19 testing and treatment is not included. State and local HIV and AIDS programs are not included. State vaccines for children program, the community health clinics or the federally qualified health clinics, the VTTC programs, transitional housing and emergency accommodation. LIHEAP is not included, tax credits. So for example, the federal stimulus check that was given under the CARES Act is not included in the public charge. The Cook County Careling Program, WIC, is not included. School breakfast and lunch programs are not included. Food pantries, Meals on Wheels, and similar programs are not included. Emergency food assistance programs are not included. Head Start and Healthy Start are not included. Emergency and disaster relief. Unemployment benefits are not included. Pandemic EBT is not included, and any non-cash benefits that are fully funded by the state or the municipality are not included. Now, this is just a small list of all the benefits and programs that are not included under the public charge rule. There are many, many more, but I just wanted to demonstrate how many programs are not included in the public charge rule and that families should definitely not be afraid of using. It's also important to note that benefits do not count against a green card applicant if they were received by their children or relatives. They also do not count if they were received by members of active military service. So for example, if the green card applicant is in active duty, the benefits that person receives do not count, as well as any benefits that were received while the person was in a public charge exempt status. So for example, like a very rare case would be a person who is a U visa applicant. And for some reason that doesn't go through and they receive benefits while they were in that category, these benefits would not count against that person. So as you saw on the previous page, any COVID-19 testing or treatment will not count against a person in the public charge test. On March 13th, USCIS published an alert that it will not consider testing, treatment, or preventative care related to COVID-19, and also urge anybody to seek any medical treatment necessary if they experience any symptoms, because it will not adversely affect any person as part of a future public charge assessment. Now, as you can see, this alert isn't very comprehensive, and so it doesn't mention anything about any long-term care that may be needed due to COVID-19 or anything of the sort. So I did want to mention that that is still not very clear, unfortunately. So now we're going to talk about that second portion that I mentioned, the totality of circumstances, which is the factors that immigration officials consider when they're making that determination of whether a person is likely to become a public charge. So these are categories that are included under the totality of circumstances. They will look at the person, the applicant's income and financial status, look at the person's age, their education and skills, their health, the family status, and then lastly, that affidavit of support. And I do want to mention, as you will see, that the use of public benefits, the prior use of those listed public benefits, is only one factor within this test. So for that first portion, the income and financial status, they will be looking at the applicant's household income. They will be looking to see if that person has any assets and resources. They'll be asking for a credit report and a credit score. And if you don't have a credit score and you don't have a credit score, then you need to ask for a credit report that shows that you don't have a credit score. They'll be asking for any debts and loans that you have, such as school loans, car loans, any personal debts. And then it's within this that they'll be asking about the use of the listed public benefits that I had mentioned. So that includes the use of cash assistance from the government, any long-term medical care through Medicaid, use of SNAP, use of federal public housing, for example. Secondly, they'll be asking about your age, looking at the age. So the main thing they're trying to see here is if you have the capacity to work and thus be self-sufficient. So under 18 years of age or over 61 years of age is not considered positive, but you are able to prove through the other categories that you will not become a public charge. So if you're under the age of 18, your parents' income or your guardian's income and that they're working, right? Or if you're over 61 years of age, that you have a job or that you have assets and resources, or that you have family members that will financially take care of you within your household. The next one is the education and skills. So we'll be looking at your education level. If you have any special skills, certifications, they'll be looking at your English level, and if you know any other languages, and they'll also be looking at your work history. Next, they'll be looking at your health. So what they're particularly interested in is if you have a medical condition that is likely to require extensive treatment, institutionalization, or if it interferes with the ability for you to take care of yourself, attend school, or work. And they're looking to see if you have health insurance that would cover, if you do have a medical condition, that will cover any costs associated with it. And so that could be either private health insurance or health insurance that is paid for by the state. So just as long as it isn't paid for using federally funded dollars is what they're looking for. Next will be family status. So they're going to be looking at the household size, particularly to see if you have a large household that you need to support financially, or if you have a household that can support you financially. And lastly is that affidavit of financial support. That is a contract that is signed by a person, a U.S. citizen or legal permanent resident who accepts financial responsibility of the applicant. And so the affidavit of financial support before this final rule used to be weighted very heavily, but now it's just going to be another factor within this totality of circumstances. So they're going to be looking at the sponsor's relationship with the applicant, if that sponsor has had previous sponsorships. And I also wanted to mention quickly that just October 2nd, so a couple weeks ago, the government submitted a notice of proposed rulemaking on the affidavit of support on behalf of immigrants to make the requirements stricter for those who seek to become financial sponsors for green card applicants. So under this proposed rule that was published October 2nd, they would require sponsors to disclose 3 years of their tax returns, in some cases, also tax returns of their household members. It would require that all the sponsored immigrants that the sponsor is sponsoring have to be included in their household. And it would require sponsors to have a co-sponsor if they have used federally means-tested public benefits within the last 36 months, or if they have failed to meet a prior sponsor obligation, regardless of their wealth today. And so this proposed rule will be up for a 30-day comment period. It's open to public comments. Anybody can make a comment. I've included the link here. It is due November 2nd. One of the most distressing things about this proposed rule is that public benefit portion. As you know, with the public charge, there has been a chilling effect of people that have disenrolled for benefits or that have not enrolled for benefits that they're eligible and need for. And this chilling effect would extend to U.S. citizens, legal permanent residents, and U.S. nationals who wish to sponsor family members and who need public benefits, especially during this COVID-19 pandemic, but who may choose not to do it because of this rule. I do want to mention that this is just in a proposed stage, so it has not gone into effect, and it won't go into effect for a while because there is a process that it has to go through. Now, the next thing I wanted to talk about, is the Declaration of Self-Sufficiency, also known as the I-944 form. Now, this is the form that will be submitted with the green card application. This is where the green card applicant will enter most of the information that is required and asked for in the totality of circumstances. So some important points is that most individuals that are subject to the public charge test are not eligible for the specified public benefits. So most individuals are not eligible for federal housing, for SNAP, for Medicaid, because those programs have certain qualifications that you have to meet. So you have to be an eligible immigrant in order to receive those programs, and most people who are subject to the public charge test do not meet those requirements. The use of public benefits by non-applicant children or family members do not count against the individual's application. So for example, if you are a prospective green card applicant and you have U.S. citizen children who are on SNAP, that will not count against you. Or if you have U.S. citizen children who are receiving Section 8 housing voucher that's prorated, that will not be used against you. The other thing is that only the programs listed in the rule will be considered in the public charge test. The use of public benefits does not mean that you will automatically be a public charge. As you can see, there are many other factors that they'll be looking for in looking at in the totality of circumstances. And also, it isn't over yet. Litigation is still pending, as you saw in that chart. So the rule could be reversed at some point in the future. Now, how can prospective green card applicants prepare for the public charge test? So as you saw in the totality of circumstances, they will be looking at the person's English level. So if you want to improve your English, you can enroll in English courses. They will be looking at your education level. So if you are able to, you can enroll to get your GED, which is the high school equivalent. They'll be looking at if you have any special skills, occupational special skills, or certifications. So if you're able, you can enroll in job training courses or certifications or licenses. As I mentioned, they will be asking for a credit report. So finding ways that you can build a positive credit score. And also they will be asking for your taxes. And so filing your taxes with an ITIN number is important. So this is the first Q&A that I have set aside because that was a lot of information. So I'll just open it up now. So feel free to write it in the chat, or if you want, you can unmute yourself.
Hi, Sarah. My only question is, yeah, and I think Jacqueline asked the same thing. If we were going to get a copy of the slides, you're right. It's a lot of information, and I feel like I'm more of a visual person, so that would be helpful.
Yes, definitely. So everybody who registered for this presentation will get a copy of these slides and a copy of the recording. Great. If there are no more questions, I will continue. So the second portion of this presentation will go over public benefits and assistance that is available to non-citizens that aren't eligible for the general public benefits, and we'll talk about how it affects the public charge. So this is a very condensed slide. It's got a lot of information, but these are public benefits for non-citizens that do not negatively affect the public charge. And so for this, we're particularly thinking of non-citizens who may be subject to the public charge test. And these are public benefits that they can use that will not affect them in the public charge. So the first one is All Kids, which is the medical insurance program for children in Illinois. The requirements for this program are that they be Illinois residents. There are certain household income level requirements that you have to meet, and the kid has to be under 19 years of age. And this is regardless of immigration status. During the COVID-19 pandemic, they are not canceling All Kids for children who turn 19. And this will not affect their public charge determination because under the public charge, they're not looking at Medicaid use for children under 21 years of age. The next is emergency Medicaid. This is available to Illinois residents who meet a certain, again, household income. This is for individuals who do not qualify for regular Medicaid. So the eligible population is, for example, DACA recipients, some people that have TPS who are in their first 1-year waiting period, lawful permanent residents who have had that status for less than 5 years, and undocumented adults. So this is for those who are 19 years and over. To qualify for emergency Medicaid, the individual must have a medical condition that has severe sudden symptoms, in which the absence of immediate medical attention could reasonably result in serious impairment to bodily functions or dysfunction of any bodily organ or part. Emergency Medicaid can be used for COVID-19 treatment and should be used for COVID-19 treatment for anybody who meets this eligible population. The next program is Moms and Babies. This is medical care for pregnant women and their babies. It covers the pregnancy and 2 months postpartum normally, and it is available regardless of immigration status. Similar to all kids during the pandemic, they're not canceling mom and babies after the 2 months, and this will not affect the public charge because they've told us that they're using state funds to cover that medical care after those 2 months period. The next program is the VTTC programs, which is for non-citizen victims of trafficking, torture, or other serious crimes. So this is particularly for applicants and their family members of applying for U visa, T visa, or asylum. The VTTC programs provide Medicaid and food assistance. The requirements are that you be an Illinois resident and again, that you meet certain household income levels. This program is state funded. So all the funds are through the state, no federal dollars are used, and so that's why it is available to non-citizens who, of course, are applying for U visa, T visa, or asylum. The next is the pandemic EBT. This is a special benefit for school-age children from age 3 to 17 that replaces free or reduced price meals that they would have been receiving at school had they not been studying virtually or have had a hybrid model. This is available regardless of immigration status. And the program has been approved to extend through September of 2021. This approval just got approved October 1st, so at the beginning of this month. So that application is not yet available as USDA and IDHS are still figuring out how they're going to administer this program for this next school year. And then the last program is WIC. It provides nutrition and other assistance to low-income women and children up to 5 years. You do have to be an Illinois resident, and again, there are household income levels that you have to meet, and it is available regardless of immigration status. So these are public benefits that are available to non-citizens who may be subject to public charge that will not negatively affect their public charge test. Some other programs that are available to immigrants that provide more holistic services are the Illinois Welcoming Centers. So the Welcoming Centers serve as a one-stop shop that provide comprehensive and holistic case management, and they also connect immigrant and refugees to social services. They host community education workshops to help immigrant and refugees learn about resources and information and do much more. The next program is the Immigrant Family Resource Program. They provide assistance to low-income immigrants to access public benefits and other human services. ICER administers this program through a network of community-based partner agencies. The next program is the New Americans Initiative. Now they provide application services to eligible permanent residents who are seeking to apply for citizenship, US citizenship, and they also help eligible people apply and renew for DACA. This program is also administered by ICER. So if you're interested in learning more about these programs or would like to find a center near you, I've included the link here. The IFRP program is great if you have any public charge questions or any questions about any public benefits that I've mentioned in this presentation. Something that's very important, especially right now during this pandemic, is that emergency assistance is not included in the public charge test. So any emergency assistance that is available through the state, through municipalities such as the city of Chicago, through NGOs, through community-based organizations, through private funds, are not included in the public charge test. So anybody who needs this and is eligible for these programs should apply without fearing a negative effect for the public charge. And so some Current examples or some current programs right now is the COVID-19 Immigrant Family Support Program of IDHS and ICER. They're dispersing one-time $1,000 to eligible households via lottery system. There are eligibility requirements. One of those is that you haven't received cash assistance through IDHS or the city of Chicago before. This lottery opened October 1st and closes October 15th, so tomorrow. I've included the link that has more information on eligibility and as well as like the screening application. The next program is the Cook County COVID-19 Recovery Mortgage Assistance Program, and that is specifically for suburban Cook County. So those who are living in the city of Chicago are not eligible for this. It's specifically for homeowners that have COVID-19 related financial hardship and that have late payments, haven't been able to make payments to their mortgage after March of this year. So there are certain income requirements that you have to meet. And again, you can't have received CARES Act mortgage assistance, for example, through IDA, through the EMA program that IDA had. So this program is open until October 16th, which is Friday. And I've also included the link. The last program that I wanted to quickly mention is that the Welcoming Centers will have a housing utility assistance project that will provide housing utility assistance to immigrants, refugees, and persons with limited English proficiency who've been affected by COVID-19 and are not eligible for stimulus checks, unemployment benefits, or public assistance. This assistance will be paid directly to the landlord or the utility company or the mortgage company, for example. This program is not open yet, but I did want to mention it just so everybody can keep it on their radar. So for COVID-19, people without health insurance and people with Medicaid, COVID-19 testing and treatment should be free. By state order, all tests and services related to COVID-19 are covered by the state regardless of immigration status. And in terms of treatment, the healthcare provider can bill HRSA regardless of a person's immigration status. So I've included ICER's Family Support Hotline here in case you have any questions or if you are charged for testing or treatment and are uninsured or have Medicaid. Lastly, I wanted to quickly mention the Immigrant Tenant Protection Act. So it's a law that went into effect last August. It states that landlords cannot threaten or evict tenants because of their immigration status. So this is very important right now that we're going through this pandemic, and there's a lot of people who aren't able to make their rent, who may be having issues with their landlord. And so it's important that they know their rights, that they cannot be evicted or threatened or intimidated because of their immigration status. Your landlord cannot threaten or call ICE because of any disputes they have with them or because of late payments. You also, of course, you have the right to live in a safe, reasonably maintained home and to ask for repairs without fearing that they will use your immigration status against you. So I just wanted to briefly mention that there is this act that protects persons that their immigration status cannot be used against them. Now we'll move into common questions and important messages. So some common questions around the public charge that we receive are, for example, I am pregnant and need help, currently registered with the Moms and Babies program, but I fear that this will be used against me. So the response to that is that Medicaid use by pregnant women, including the 60 days after giving birth, will not be counted in the public charge test. And as I mentioned earlier, because of COVID-19, they are extending Moms and Babies after the 60 days, and they're using state funds for this. So because it's state funded, it will not affect a potential green card applicant. The next question is, I have citizen children who receive food stamps and Medicaid. Can this affect me in the future when I want to adjust my status? The answer is no. Your children or any of your family members' use of public benefits will not be considered in your public charge test. They, of course, have every right to receive these public benefits. And the last question is, I used WIC 10 years ago. Will this affect my permanent resident application? So although WIC is a public benefit, it is not included in the listed public benefits under the public charge. Also, the use of non-monetary benefits that before February 24th will not be asked in the public charge test. Now we have some scenarios just to, dive into the public charge a little more. So this is Anna, and she was just granted asylum. She has started using SNAP and is worried that it will affect her green card application because of the final public charge rule. Asylees are one of the exempt categories from the public charge test. We encourage Anna to stay enrolled in the public benefits programs that help her well-being. The next scenario is William, who has unfortunately contracted COVID-19 and has been admitted to a hospital for treatment. He is fearful that the treatment, which will be paid by emergency Medicaid, will be used against him when he adjusts his status. USCIS stated that COVID-19 testing and treatment will not be used against a green card applicant. Also, emergency Medicaid is not included in the final public charge rule, so its use will not negatively affect his application. He should, of course, seek the treatment needed for COVID-19. Next, we have Leslie and Dominic, whose children are enrolled in Medicaid and SNAP. They heard about the public charge rule and are fearful that their children's public benefits use will affect them if they adjust their status in the future. What should they do? As mentioned, the use of public benefits by children does not affect the parent's green card application. The public charge test will only look at the applicant's use of the listed public benefits. They should keep their children enrolled in Medicaid and SNAP. Now, again, some important messaging that I have reiterated throughout the presentation. Most immigrants subject to the public charge do not qualify for the benefits listed under the new public charge rule. Benefits that are used by your children or relatives will not be considered in the application for legal permanent resident. The use of public benefits does not automatically make you a public charge. And of course, talk to an attorney if you think you will be subject to the public charge. Some resources if you're interested in learning more about the public charge. There is a national website called the Protecting Immigrant Families that focuses on the public charge at the national level. It's protectingimmigrantfamilies.org. We also have a website specific to Illinois. It's protectingimmigrantfamiliesillinois.org. And if you're interested in getting regular emails and public charge information, please sign up for our listserv. You can sign up by sending an email to pifillinois@povertylaw.org. Some other resources, as I had mentioned, the ICER hotline that supports immigrant families. If you have any questions about public benefits or having any issues, there's also the Immigrant Family Resource Program that helps, as mentioned, helps low-income immigrants apply for public benefits or any social services. There is a website called getcareillinois.org that offers help getting healthcare coverage. And if you have coverage, it helps you to understand how to use it. This is available in 5 languages. And if you're seeking legal services, there is a legal directory that has information and NGOs that provide free or low-cost immigration legal services. And the link is immigrationadvocates.org/legal directory. And finally, this is my contact information. If you have any questions that you want to ask me directly, you can email me. We also, the Latino Policy Forum, we post information on our Facebook and our Twitter page. So if you would like, you can also follow us. And that is the end of the presentation. I will open it for any Q&A. Okay, so I have a question from Jocelyn Rodriguez. So if they're being threatened or illegally evicted, what can we do? This is a great question. So I will share this information in the follow-up, but MALDEF, which is the Mexican American Legal and Education Fund, is collecting information on people who are being threatened or being evicted because of their immigration status, and is connecting them to representation, to legal representation. So I can definitely share that information when I follow up with the presentations and the recording. I have another question about the $1,000 grant, which is only available until tomorrow night. Is there a chance you can send out the slides this afternoon? Yes, I can definitely send these slides out this afternoon. And also, if you want to check that out, just go to icir.org. So ICIRR.org. And they have information on there, I'm pretty sure on their homepage, about that $1,000 grant. Someone commented that they have extended it to October 19th. That's great news. I hadn't heard that yet. Great. If there are no other questions, I want to thank everybody for joining our webinar today. I will follow up with the slides and the recording and any follow-up material that has been requested. So thank you, everybody. I hope you all have a very nice day.